Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract and independent contractor agreement issues. Today, I'm going to talk about how to decline a job offer after you have signed a contract. So this is a tricky one, but let's kind of walk through the process. So if you are going to be an employee or an independent contractor working with an organization, and you are in a position that requires an employment contract or independent contractor agreement, generally the process is they'll discuss terms initially, they'll maybe give you an offer letter, and then once the terms are agreed upon, then they'll provide you with an employment contract or independent contractor agreement. You sign the agreement, and then whatever the start date is, you would anticipate starting when you can. Now, what happens if you sign the agreement and then for whatever reason don't want to go through with the job, can't go through with the job, something else has happened in your life that prevents you from starting the job? Well, first you need to look at the terms of the employment contract. In any employment contract, there's going to be a section that's called termination, and that dictates how a contract can be terminated. And most contracts require some kind of notice prior to terminating the contract. So even if you sign an agreement and you haven't even started, well, you still have to provide notice that you are going to terminate the contract, and the contract's also going to say how you can provide notice. And most of the time, or not most of the time, all of the time, it's written notice provided to the employer either through hand delivery or certified mail or something like that. So the first thing you need to identify is how much notice do I have to provide the employer to terminate the contract. Now, second, are there any penalties associated with terminating the contract before you start? I would say it's relatively rare, but there are contracts that will explicitly state if the employee signs the contract and is scheduled to start at a certain date and doesn't start on that date, they will owe the employer a monetary penalty. It could be $5,000, $10,000, $15,000, and they justify that to say it covers their recruitment costs and onboarding and maybe credentialing if there's insurance companies or healthcare facilities associated. So if there is some kind of penalty and you decide not to start for whatever reason, they could attempt to enforce that, and then you would be bound by whatever the penalties associated were. On a practical level, I find if someone can't start a job for legitimate reasons, and what I mean by legitimate reasons are, it's not because you found a job that pays you more. It's maybe there's a sickness in your family or personally, or there's been some kind of change as far as what career you want to go into, like a personal reason that's just not going to work for you to start the position. Approach the employer, talk to them like a normal person. This is what's going on in my life. I understand I signed the contract, but I'm just not going to be able to start. If you approach it in that way, I find most employers are, for the most part, agreeable and amenable to just letting the person go. Now, if you're someone who's just simply pitting one job against another, or you've even signed a contract and you say, you know what, I know I've signed a contract, but I have another job that's offering me twice as much, will you match that? Generally not going to be, the employer's not going to be super receptive to that. So if that is the situation, then I would be careful about what I would, I guess, provide to you, the organization that you sign the contract with, because I can promise you they're not going to be super excited for you to leave a position if it's simply for more money or benefits or whatever. So just going over, first, identify how you can terminate the contract, what the notice requirement is, what the penalties associated with breaking the contract will be if it's explicitly stated, and then kind of the last thing you need to think about are the restrictive covenants. even if you haven't started a job, if you've signed an employment contract and there are a non-compete or a non-solicit or whatever, those restrictive covenants are still going to apply even though you didn't start. Doesn't seem fair, but that's reality. You sign the contract, you're bound to the terms. Now, maybe you're in a state where non-competition clauses are completely unenforceable. Only a handful of those. I would check and see what the rules and kind of general case law is regarding non-competes in your specialty in the state that you're in. But that's another consideration. If I back out of this agreement and the non-compete does apply, am I trying to move to a job that's in that restricted area during the time period? So that's one more thing you need to think about if you sign a contract and don't want to start the job. It's not great. Look, there's no easy way. There's no black and white. This is exactly what you need to do. Every situation is a little bit different. The best way of handling it, in my experience, is just to act like a normal person, talk to the employer like a normal person. This is what's going on in my life. This is why I can't start this job. Can we just kind of wash our hands of the situation and move on? And obviously, the more notice you can provide, the better. If you give the employer 4 months notice, like let's say, I do a lot of contract review for physicians. So some of them sign employment agreements a year in advance of when they're done with training. If you give notice to the employer 6 months before you're supposed to start, well, that allows them plenty of time to find a replacement, and most likely they're not going to make a big deal out of it. If you give notice to the employer 1 week before you start, you can bet it's going to be a problem. And they have gone through credentialing with insurance companies, facilities, malpractice insurance. Maybe they staffed up to meet the needs of the physician. Like, think of all the things that they would have to do, and then providing them with only 1 week notice is likely going to be met with some negative emotions on the part of the employer. So keep that in mind. So anyway, hopefully that was helpful. If you have any questions, feel free to contact my law firm at the phone number listed below in the description, and the website's down there as well. Anyway, hopefully this is helpful, and appreciate you watching the video. Thanks.